Welcome to the Roetzel HealthLaw HotSpot. HealthLaw HotSpot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome. I'm Ericka Adler, a shareholder at Roetzel and Andrus, and I run the healthcare department. Today, you're on the HealthLaw HotSpot, and we are joined by two of my colleagues. I have David Hochman, who's also a shareholder at Roetzel and Andrus, a member of the HealthLaw Group and managing partner of our Chicago office, and Michael Brohman, also Roetzel shareholder, and he's part of the employment litigation department. And we're really excited to have Michael here because our topic for today is difficult employees, particularly those with our healthcare clients, physician practices, dental practices, and other types of employers. So today we're going to be talking about how should you be handling those types of employees when they become disruptive or otherwise engage in behavior that might be grounds for termination. So to get things started, Michael, why don't you tell us a little bit? I know that many states, including Illinois, employees are considered at will. But why don't we talk about what that means and whether that stops us from being able to terminate an employee who's become difficult?
Well, an at-will employee is somebody who can be terminated for any reason or no reason at any point in time, with or without notice. And yes, most employees at a physician-run practice are employees at will. Usually it's only employees who actually have contracts with the employer who may have some protections. But just because an employee is an employee at will doesn't mean that an employer can just willy-nilly terminate somebody, because there are issues that one has to consider.
All right, great. So if you have a difficulty with an employee, and let's just think, non-obvious things. So this isn't somebody who's lost their license. This isn't somebody who stole or got convicted of a felony, because I think we know those are kind of more the automatic things. But let's say we have somebody who is doing something that is disruptive or to the practice, or bad-mouthing the practice. Maybe somebody who's stealing prescriptions, or you think might be using drugs. We've come across lots of these examples. So when an employer calls you and says, hey, I've got a problem with this employee, whatever the issue might be, what kind of advice do you give them?
Well, first and foremost, I ask the client what they've done to document the issues that they've had with the employee. It's so important to document. I know it's sometimes a pain in the neck for an employer to spend the time, or the office manager to spend the time documenting, but it is extremely important to document any time that you have an issue with the employee, because it's going to help you later on if the employee wants to take some sort of action against you. You have to understand, we live in a society where people don't want to accept responsibility for their own actions. So if they're terminated, if they're disciplined, they are always going to be looking to blame somebody else, and it's going to be the employer. And they'll talk to all their friends and colleagues, and they'll all say, well, you know what? You should go after the employer for this or this or that. And that's why it's very important for the employer to take these steps to protect themselves.
Okay, so sorry, David, go ahead.
No. So Michael, how does age enter into all of this?
Well, actually, all the protected classes enter into this: age, sex, race, national origin, pregnancy, sexual orientation. All of those categories enter into this. Even though somebody is an employee at will, it doesn't stop an employee from arguing later on that they were discriminated against for whatever classification they're in. So if you terminate somebody who's over the age of 40 and therefore protected by the Age Discrimination Act, you're going to have to respond to that claim, regardless of whether or not that you had the absolute right to terminate the employee as an employee at will.
Right. I think that's part of the problem too, though, because sometimes somebody's done something and an employer will call you and say, I want to terminate this person for this reason. And I always say, well, what class might they fall into? Is it race, gender, whatever? And a lot of times employers will be afraid then to terminate someone, even if that person literally did something really bad and specifically violated a term of their employment agreement. So what kind of advice do you usually give when that's the case?
Well, again, I start with the documentation. I always tell the employer to document everything. I tell the employer to be consistent. Okay. If you are going to discipline one employee for being late, make sure you discipline all employees for being late. Okay. If you have an employee manual, okay, I tell the employer to make sure that they're following the safeguards that an employee has in the employee manual. All those things that are very important for the employer to make sure they're doing to put themselves in the best position if an employee were to try to take some sort of action against them.
So, Michael, some of the more difficult cases I think I come across have to do with an employee whose performance has not been very good, but who also has a disability, actual or maybe a potential disability.
Right.
Can you talk a little bit about what additional issues have to be addressed in that case?
Well, obviously, if you have somebody with a disability, the law requires you to make sure that you are giving the person a reasonable accommodation. The law requires you to sit down with the employee to make sure that the two of you, employer and employee, can work on some sort of agreeable, reasonable accommodation. Not something that would pose an undue hardship on the employer, but something that is reasonable. That's all the law requires you to do. So in that situation, first and foremost, if the employee is a problem but is in that class, I say, well, let's first try to figure out what's going on with the disability. What have you done from a disability standpoint to make sure that you are following the law and you've given the person the reasonable accommodations that the person is looking for? Okay. Obviously, there's going to be times where you've done everything from a reasonable accommodation standpoint, and you just cannot continue with the employee, and then you can terminate the employee. But again, the idea here is to put yourself in the best position to defend yourself. Okay, that's documentation, that's following whatever kind of reasonable accommodations that the employee may need, any kind of doctor's notes that the employee may need. You do all that stuff. You can never stop an employee from bringing an action against you. All you can do is put yourself in the best position to defend yourself.
Yeah. Can you ask an employee to get documentation from their physician as to their disability?
Absolutely. If the physician is going to put a limitation on the employee's work, you can require the employee to give you a physician's note.
So, Michael, what about the situation where you have a problem with an employee? The first thing you would do is look at their contract, if they have one, to see kind of what grounds you could terminate for. And most contracts have grounds for termination, and then they have what we call without cause, which is just some amount of notice. Is there a different outcome when you have somebody in one of those classes? If you were to choose to say, I'm just going to let them go without cause so that I don't have to say what the reason is I'm terminating them. Does that alleviate any of these concerns about those protected classes?
It will not necessarily prevent you from being the recipient of a cause of action for discrimination or retaliation. But I think that's probably the best approach. In fact, I always advise employers to be as short and simple as possible when they're terminating an employee. Don't get into the actual causes. Just make sure you're documented them. But because there may be, if and when the employee winds up suing you, there may be other issues that you really want to bring up. And if you didn't raise them at the time, then maybe those other issues are considered not as important. So I always tell the employer, if you have that right to terminate for no cause, make it short and simple. Just basically say to the employee, things aren't working out. We're going to have you leave.
All right. And do you, I mean, like maybe you could speak to the average employee, what rights do they have to bring a claim, and, how would they go about doing it? Are they allowed to just send you a demand letter? Does it start when they hire a lawyer? What are their options?
Well, obviously, the first option is either the state Department of Human Rights or the EEOC. Those are both employee favored organizations that are designed to make sure that an employer is not violating the basic rights of an employee to be protected against discrimination or harassment. So most employees won't sit there and get an attorney in the very first instance. They'll file a complaint with either the EEOC or with their state Department of Human Rights commissions. And, depending on the state or where you are, those kinds of commissions will actually investigate the claim. In the state of Illinois, for instance, the Illinois Department of Human Rights is probably more fact intensive in their investigative role than the EEOC, requires the employer to do more work in responding to a claim. But both of those organizations really are designed to investigate the claim, see if there's any merit to the claim, and then if there is, then maybe the department will then initiate a formal action.
All right, great.
Now, again, these kinds of commissions are there to protect the employee and, most importantly, to make it cost effective for them. So while the employee is bringing these claims, they're not spending any money. It's a State Department or the EEOC investigating these claims on the government's dime. The employer, of course, has to respond, and they're obviously taking the time and effort. I would urge an employer to hire an attorney to represent them in these kinds of proceedings. I think you need to have somebody who knows what they're doing to respond on your behalf. So I know some employers try to respond and then later on get the attorneys involved, and the attorney has to sort of reinvent the wheel. So I think in the very first instance, if you are served with one of these kinds of complaints, either by the EEOC or by the state, hire an attorney and work with the attorney in responding to it.
Michael mentioned talk about the exit interview. We didn't really talk about retaliatory discharge or wrongful termination.
All right, well, let's talk about the exit interview first. Okay, when you finally made a decision to terminate the employee, and of course, it's a difficult decision on your part. You want to make sure that before you do so, you're protected in the event the person does bring some sort of action against you. So what should you be doing in this meeting? Well, first and foremost, don't attend the meeting by yourself. Okay, make sure there is one other person, an office manager, one of your other partners or what have you, participating in the meeting sort of as a witness. So that way it doesn't become a he said, she said type argument later on, and you have somebody who can verify what occurred. Secondly, you document what occurred, and put whatever occurred at that termination meeting in the person's employee file, personnel file. Third, as I said earlier, say as little as possible. Don't go into all the specific reasons why you're taking the action that you're taking, but be as short and simple as possible. Basically say things aren't working out. We have to make a change. Today's your last day. The timing of it, I generally tell employers that if they can, make sure that they have this meeting at the end of the day or at the beginning of the day, when there are no other employees and certainly no patients or customers around, because you want to make sure that the employee doesn't have an outburst, and you don't want that outburst to affect other employees, and certainly you don't want that outburst to affect the patients or customers of the employer. So pick a time at the end of the day. Friday, 5 o'clock is usually a good time, especially if you're not open on a Saturday. That gives you an opportunity to recover from it and plan on how you're going to respond to employees on Monday who say, "Where is so-and-so? Why isn't so-and-so here?" And by the way, when that happens, you say as little as possible. You basically say, "So-and-so no longer is working here, and we're moving forward." Don't go into the issues that you had with a particular employee. When you have, probably even before you have that meeting, okay, when you've made the decision to terminate the employee, make sure you're protecting yourself. Make sure, for instance, if the employee has access to the computer system, okay, make sure you have eliminated that employee's access to the computer system, because if you haven't and the employee still has access to it, you never know. You could have your computer system sabotaged by a very upset employee. Make sure you get any company property from the employee before the employee leaves. I generally advise the employer to escort the employee out of the building, go with the employer with the employee to the employee's desk or workstation, go through what is actually the employee's as opposed to the company's property. Let the employee take his or her property with her, and then escort him or her out of the building. So those are some of the things that I would do if I were an employer.
So Michael, our audience here is a lot of our dentists and doctors. Okay, so that's a different kind of employee maybe than some of the ones that people might think of when they hear you speaking. What are some of the particular issues? You have a professional person. I mentioned early on that some issues that arise with the professional employee might be a little bit different than just the receptionist or the office worker, right? We have issues that affect a reputation, that are liability issues. It might be related to prescriptions. It might be related to malpractice, et cetera. And sometimes those issues are covered specifically in an employment agreement. Sometimes they're not. Are there different ways that you would approach terminating a physician? We're not talking about breach of contract where they didn't show up or they didn't do their job, or they're talking more sophisticated issues than that. Well, how would we handle a professional employee a little bit different? Or is there any difference? Is an employee from your perspective?
Well, there probably is a difference because the professional employee more often than not is going to have a contract which defines his or her rights. So, and I generally recommend to an employer that if they've made a decision in the first instance to terminate a professional employee, okay, I basically say, okay, exercise your right to terminate that person for no cause at all, even if it means giving the person the 90 days, 60 to 90 days notice. I say, pay the person for the 60 to 90 days. Don't let the person come back into the office. Just have the person go sit at home, fill out, if they have to do any kind of fill out medical records or whatever, but you have the right under the employment agreement to direct their activities. So I would not have the person continue to come and work even though I'm paying them, because usually if somebody's been told that they no longer are wanted at a facility, they're going to poison the work spot. They're going to be complaining to other employees. And you don't want that. You want to have a good working relationship with your employees. You don't want the employees to be poisoned by the bad attitude of somebody who's been discharged. So in the very first instance, I tell them, go ahead, exercise the right to terminate the person for no cause and pay them for the period of time. With a professional employee, you may have rights under the contract, for instance, for tail insurance. They would be responsible for paying their own tail insurance. Generally, what we do is we write a letter that we give to the employer to hand to the employee, which basically reminds the employee of their continuing obligations under the agreement. payment of a tail insurance and what kind of rights we have there. If they have a restricted covenant, let them know that we plan on enforcing the restrictive covenant against them. Whatever other kinds of rights they have, and just pay them whatever they're entitled to. Generally, you try to with a professional, you may work out some sort of a severance agreement. In those kinds of circumstances, you have the difficult issue of what if the departing employee wants you to give a letter of reference. Okay, that could be problematic for a employer, especially if there were performance issues. Generally, what I do is I recommend to the employer that if they're going to give any kind of a letter of reference, all they basically do is confirm the dates of employment and what the duties were of the employee, and if the employee wants the pay that they were giving to the employee.
So, on a related point, you're absolutely right. With a professional employee, we always have tail and non-compete issues to think about. However, many contracts are written so that, who's responsible for payment or whether the non-compete can be enforced are tied to the reason for termination. So if you've terminated somebody and you think it's a valid for cause, and they're fighting it as being not valid or wrongful, right? I guess, how do we figure that into who's responsible for tail and non-compete at that point? Very often, if you choose to let somebody go without cause as a smoother form of transition, you've also given away your ability to enforce the non-compete, and you become responsible for the tail. So
I don't think you've given up your right to enforce the covenant not to compete.
Very often in the contract, it says that if we let you go without cause, we won't enforce the non-compete. So I'm just trying to think, like, the decision about how to terminate somebody can also impact the outcome to the employer in terms of that contract. So how do we kind of fit these together? Especially if there's going to be some kind of wrongful termination claim. Do we have to wait until a decision's made as to whether it was wrongful or not? Or do you take that into account when you're deciding what type of termination you would recommend?
Well, again, in some of these employment contracts, there's very specific acts that if the employee commits, if they've been suspended by a hospital, if they've lost their license, if they've been disciplined by their state licensing board, there's usually a whole plethora of items that could constitute for cause. So if you have something like that, then go ahead and enforce your rights to terminate the person for cause. If it's more of, I don't think that this person is really doing a good job, and it's really a performance issue, and you might have rights under the employment agreement to terminate, but can be a little muddy. Maybe you have to give the person notice of the kinds of issues that you're having and giving the person a right to cure those deficiencies. That gets a little bit more difficult. And under those circumstances, you have to make a business decision. What do we really want to do? Do we care about the covenant? If this person has some performance issues, are we really going to be hurt by the person leaving if we terminate them for no cause? It becomes a business decision in that.
Right.
I think it's also a function of how long they've worked for the employer. If somebody's been there a year, their ability to leave and compete with the practice is certainly going to be less than if they've been a longer term employee.
Well, covenants not to compete are a whole different topic altogether, because just because somebody has a covenant not to compete does not mean it's enforceable. An employer has the burden of demonstrating there's a real protectable interest in a covenant in protecting against the competition. A lot of that analysis is very fact specific. What did the employer do to introduce the employee to patients, to referral sources, things like that? Did the employer give valid consideration? That's become an issue, certainly in the state of Illinois, for the restrictive covenant, because it could be determined to be unenforceable if there was no consideration if the person worked there for less than 2 years. So
David, correct me if I'm wrong. I think you're really saying that how long somebody's worked there determines how much you care too about enforcing a non-compete in the first place when you're making that business decision. Michael, two things I see on the termination front that I wonder about is a lot of very vague reputation related grounds for termination. And that makes me crazy. I know we have some language that we use, but I think we try and frame it to be reasonable and good faith and about interaction with third parties, et cetera. But when I look at contracts, I see a lot of grounds for termination where you just do anything that in the sole opinion of the employer impacts their reputation. And I try and, fix those when I can, but often I can't. So how enforceable do you think those are? I mean, somebody, for example, with the COVID situation and people going on social media and complaining about access to PPE, et cetera.
That becomes a very big issue because
right.
If you try to terminate an employee for a cause and you're using that sort of catch-all provision as your cause, an employee can always file a lawsuit against the employer for wrongful discharge and basically contest whether or not you had cause. And then it becomes a case of what does the employer have to show that this person truly violated his or her obligations, and obviously the employee's response to that. And they're obviously, especially if you're talking about a lot of money, if you're talking about a highly paid professional employee whose reputation could be hurt by being discharged, you're going to see somebody contest those. And we've seen that in the past with some of our clients.
And those kind of provisions make me crazy. And then one other thing about a termination provision, I don't know if you guys have come across this, but I don't put this in my contracts for employers. And I really hate when I see this on the employee side. It requires both parties to provide notice, let's say 90 days, but then gives the employer the right to accelerate the termination date to any date it chooses. And that would be the last day without honoring any compensation or benefits for the remaining notice period. From the physician or employee or whatever perspective, they went through the process of providing proper notice. They probably don't have a job that's starting yet. And yet they're being told, oh, thanks for giving us the notice. Tomorrow's your last day. And it just seems so unfair to me. And I know maybe this is a little bit off topic, but have you seen anybody contest those kinds of provisions? How do you feel about it as a litigator?
Well, anytime, the problem with contracts is, especially with professional contracts, is parties are determined to know and understand what they're signing. So it's very difficult for a professional employee to basically argue, I was at an unfair disadvantage and I was effectively forced to sign this contract. It's unconscionable.
Right.
So that'd be very difficult for the employee to win. That doesn't mean they wouldn't try,
right.
But I think that the employer probably is in the better position with that kind of a contract.
Right. And unfortunately, a lot of doctors sign contracts without understanding, reading them, or having somebody counsel them. And that's typically, when they come to us, this has already happened. They've already had their employment date, termination date accelerated, and there's nothing we can do. Or they signed a contract, are thinking of leaving, want to give proper notice. And then we see that provision in there. And we're like, oh, you could give your notice, but just, understand this could happen. And really hard to advise clients.
Yeah, I think that.
Well, and what I always, when I'm in the negotiation stage, I always basically tell if I'm the employer, I urge the employee or prospective employee to hire a lawyer, right, so that this is negotiated and they've gone over with a lawyer before they sign it. I think that would, again, put the company in a much better position.
Right.
Even if you're signing an employment agreement with a large institution that has a policy that they want all their employment agreements to be uniform, and there's very little ability to negotiate the terms, it's still critical that the employee understand what it is he's agreeing to.
Exactly right.
As opposed to finding out about this is a problem after an issue arises.
Right. I always say that the review of the contract, I may not help you get a single change, but you won't walk away not knowing what's in here, and you won't be able to say, oh, I never knew that was in there. Good or bad, you'll understand what you're signing, right?
And by the way, not only for the initial contract, should you try to insist that they get their own lawyer, but let's say you are are terminating the employee and you're going to give some sort of a severance package to the employee, you want to make sure that that employee has gone through the severance agreement with an attorney beforehand. In fact,
Right.
Illinois law has changed in the last couple of years, giving an employee more time to consider whether or not they're going to sign a severance agreement. You just can't sit there under Illinois law and give an employee, here's severance agreement, sign it today, and that's it. They'll have 21 days to actually consider it. They have a right. They'll usually have a right to revoke it if within 7 days after it's signed under Illinois law. And you should always urge the employee to be represented by their own counsel, or at least show the agreement to counsel before. And when I do a severance agreement, I actually put language in there that the employee has had the opportunity to review the agreement with an attorney. Whether they do so or not, I put the language at least saying that they had the opportunity to do so.
All right. Okay, well, I think we need to really wrap up. This has really been a great topic. I think we could talk about it forever. So, Michael, we're going to need you to come back. Maybe we can dig in a little bit further
Whatever
on some
you want.
Points. Are there any last comments that you or David want to make on this topic?
Well, again, I cannot emphasize enough, and I know I've said this several times, the importance of documenting issues with employees. I cannot tell you how many times I've received a call from a client saying we've got this issue with an employee, and the first question I ask, well, have you documented the problem? And the answer is no. It puts an employer in such a much better position to defend oneself from the inevitable lawsuit. Take the position that any employee you have in this day and age is never going to look in the mirror and blame themselves for it happens to them. They're going to look to blame somebody else. If you go to it with that kind of an attitude, I think it makes it much a matter of common sense that you would document everything that happens with the employees, so you put yourself in the best position to defend yourself.
Yeah, I would add that employment law issues are probably some of the most difficult legal issues that an employer is going to face.
Absolutely.
And issues that have a lot of potential liability, both current and on a long-term basis. So it's not an area of law that you want to go and try and navigate by yourself.
Agreed.
Great.
All right. Well, thanks everyone for joining us for the HealthLaw HotSpot this week. And please go onto our YouTube channel, the HotSpot, and see some of our prior podcasts. We hope you'll enjoy them. And you, of course, can look up more information at ralaw.com if you want to know more about our practice. We'll see you next time.
Use of the Roetzel HealthLaw HotSpot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel HealthLaw HotSpot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.